So, Brandon, I'm 74 and I'm past my required beginning date. So if I die and I leave my IRA payable to my 40-year-old spouse, how soon will the spouse have to take anything out of that IRA?
Yeah, so that's one of the special beneficiaries of the IRA that gets the old stretch rules. So they would just operate just like the old rules where you would take the IRA distributions out over the life expectancy of the spouse.
So what if the spouse was 80 years old? Would it still have the same result?
Same result would still apply, but since you're younger than the spouse could choose to delay the distributions until you reach your required beginning date or actually use your life expectancy to calculate our distributions.
What if the spouse does a rollover?
Then the spouse would take the requirement of distributions just like an IRA owner would have to. As an 80-year-old past the required beginning date, there would be requirement of distributions each year for that spouse, and she could change the beneficiary. She could transfer the IRA. She could do, just as if she owned the IRA herself.
But what if she was also a puppet?
Well, then if you left it to a puppet, that would not be a designated beneficiary since it's not a person, and distributions would have to come out over the deceased plan owner's life expectancy using that ghost life expectancy rule.
Could it be a disregarded puppet because of a third tier rule?
It could possibly be if you left it to your spouse, and then if your spouse predeceased you, you left it to your kids, and then if your kids predeceased, it was to the puppet. Now the puppet would be disregarded under these new rules, which is a nice benefit for a lot of us estate planners that draft complicated trust with potential charitable beneficiaries or puppets as beneficiaries. These new rules give us a lot of flexibility.
There would need to be two people to die before I could benefit in order for me to be disregarded.
Correct.
Well, I even know who I want those people to be. Right. Let's start this show very soon. Be Tuesday, 3 p.m. I'm Alan Gassman, also known as the voice of the puppet. And this is Brandon Ketron, the brains behind the operation. And we're going to talk here for 30 minutes on the new IRA distribution proposed regulations. Now, a lot of you know that the Secure Act was passed and came into effect January 1st, 2021, to make a lot of changes to how IRA payouts work. And the general thought of Congress was we're giving people a great tax deduction and great deferral, allowing them to fund IRAs and pension plans, but we don't get to tax these things until after these people die. And then once they die, we're waiting a really long time to tax it. So let's better balance the federal government by going with a 10-year payout, getting people to take their money out within 10 years of death, as opposed to a lifetime payout, except for certain exceptions. So they passed that law, the Secure Act, and it made us feel very insecure because it was very confusing. It was layered on top of the previous law, which used even different definitions and different rules. So we have now obsolete regulations from the prior law, the confusing statute of the new law, and now, as of late February, new proposed IRS regulations. Now, the proposed IRS regulations are mostly very good and very clear, but not all very good and not all very clear. The nice thing about Treasury Department proposed regulations is that you can rely upon them if you choose to do so. So these regulations have very good news for surviving spouse trusts. They have very good news for the trust for disabled or critically ill individuals. They have good news for a lot of people. and they are more reliable and more clear than what we had before. So even though these proposed regulations are going to change, most likely for the better, we can now begin relying on them. So those of us who represent families that have disabled or critically ill individuals, or people who want to benefit their spouse and children, it's better to use newer forms and to get right on this as opposed to waiting until the final regulations come out. So that is my soapbox introduction. Now, for those of you who are CPAs and lawyers, we do not offer continuing education credit, just too difficult to do. But we hope that you will be able to use this knowledge for others. For those of you who would like to ask a question, you can click on the question pyramid there and then type in your question. If we know the answer, we will answer it. And if we don't, we will pretend not to see it. Please join me Saturday at 11 a.m. Eastern Standard Time if you want to listen to a talk about spousal limited access trusts and what a PhD scientist thinks about estate planning. And then the following Saturday, hot topics and best strategies for estate tax planning. And Marty Shinkman is going to talk about the human aspects of estate tax planning. So this webinar is going to be posted to our YouTube channel in a few hours. So you'll get a copy of it that you can click on, and then also you'll be able to see it in our YouTube channel. And we're going to do a 90-minute talk on this on Thursday, but it's not as free as this one. It's a little bit less free than this talk. So Brandon, what would you like to start off with here on page 9 as far as reminding the viewers or telling them for the first time what the Secure Act did?
Yeah, so this is just a refresher here on the Secure Act changes, and one of the most important one is that they changed the date that you're required to start taking required minimum distributions from 70.5 to 72. So they gave you an extra 1.5 years there, but in exchange for that, they eliminated the ability to stretch your IRA distributions out over the life of a beneficiary after your death, and require that in most circumstances that everything comes out within 10 years of your death. Now there's exceptions to that rule, and generally speaking, these apply when you leave it outright directly to one of these beneficiaries or to a conduit trust, and we'll get into what a conduit trust is in a few slides, but essentially that's a trust that distributes everything that it receives from the IRA out directly to a beneficiary of that trust. And if you have one of those circumstances and you leave it to a spouse, a minor child, a disabled beneficiary, a chronically ill beneficiary, or someone who's not more than, or someone who is less than 10 years younger than you, you still get that old life expectancy stretch distribution rule where you have required minimum distributions over the life expectancy of the beneficiary. Any other beneficiary, everything comes out within 10 years. So that's the general rule. So, not a whole lot has changed as it relates to those rules. We just have different interpretations now of what we can do with, particularly with trust drafting. There's a lot of things in the proposed regulations that help us out to get into one of the eligible designated beneficiary categories and not into this more harsh 10-year rule.
Okay, very good. And then everything we're going to mention here on page 10, we're going to mention at least 1 or 2 times again before we're done here, because we like to repeat ourselves. It helps memory. But Brandon, what are the key takeaways from these proposed regulations?
Yeah, so number one, there's a lot going on here. We're still working on it ourselves to figure all this out. So as we learn, we'll continue to do these types of presentations and write articles and try to inform everyone as we continue to learn ourselves. Number two, there's a really unfortunate aspect of the proposed regulations. This is one of the ones that a lot of us are scratching our heads on, and is really one of the only unfavorable aspects of these proposed regs. And that's if you have an IRA owner who's over the age of 72 and passes away, so they're taking those required minimum distributions, then if they die and leave it to, say, their adult children, so the 10-year rule would apply, what we all thought historically would apply here would be that you just wait until December 31st of that 10th year and then distribute everything from the IRA. Nothing required to be distributed in years 1 through 9. Well, unfortunately, the proposed regulations came out and said, nope, years 1 through 9, you take distributions based upon the old rules where you have a life expectancy payment based upon the life of that designated beneficiary. So 3-4%, as an example, might have to come out of the IRA each year in year 1 through 9. And then in year 10, everything comes out. Now, that only applies after the required beginning date. If you died before your required beginning date, so you died before reaching the age of 72, then you do get that full 10-year deferral capability. So there's 2 different 10-year rules that can apply. We'll see what ends up with this in the final regulations, but that is one of the unfavorable aspects of the proposed regs.
So let me just mention, it's not actually the 72nd birthday. It's whether you die before April 1st of the calendar year following the calendar year of your 72nd birthday. But if you're feeling not so good in March of the calendar year following the year you turn 72, you may not want to be in a hospital because your loved ones may terminate you so that they don't have the life expectancy payout during those first 10 years. So that April 1st of the year after you turn age 72 is the magic date. Try to stay healthy until then. Now, Brandon, if the over 72-year-old dies and the beneficiary is a child age 50, do they have to use the 74-year-old's life expectancy or the beneficiary's life expectancy for the minimum payout during those 10 years?
Yeah, they would use the beneficiary's life expectancy for that years 1 through 9 to determine those payouts. Or if you have multiple beneficiaries, it would be the oldest designated beneficiary's life expectancy that would apply to calculate those payments.
Okay, all right. Now, the second nice thing under the proposed regulations that we really like a lot is that under the old rules, in order to have a stretch trust, by the September 30 of the calendar year following the person's death, you had to have only people as beneficiaries of the trust. So you couldn't have charities, you couldn't have creditors, you couldn't have companies as beneficiaries of the trust. Now you can, as long as they have to wait until 2 successive people die. So we have a new definition called a first-tier beneficiary. That's someone who's able to receive distributions immediately. That's usually a surviving spouse. Then we have a definition of a second-tier beneficiary. That would be somebody who can't get anything until the first-tier beneficiary dies, and then they are eligible to receive benefits from the trust during their lifetime. So then you get to the third-tier beneficiary. They have to wait for at least 2 people to die. Using a tier 1 person must die, then a tier 2 person must die, and then it can go to charity, or then it could go to a company, or then it could go to a creditor. So that is a very useful provision. So what a lot of people are going to do is they're going to they're going to have the beneficiary of this trust be their spouse and their siblings. And then they're going to say, especially if they have a sibling older than their spouse. So instead of saying spouse and children, in which event it has to come out over 10 years, you would say my spouse and my oldest unhealthiest sibling until they are both deceased, and then my children, and then you could get the lifetime payout over the spouse's lifetime. So we'll be seeing a lot of that. The other thing that the proposed regulation says is that you can change things all around until that September 30, what we call the designation date. So, you die on December 3rd of 2022, and by September 30 of 2023, your family has gone to court and had the judge change that trust all around. And that's going to be fine with the IRS. And if you have what we call trust protectors in the trust who have the power to amend the trust, then you won't have to go to court to get a reformation. So I think those are really, really important points that give us plenty of reason to go ahead and redesign these trusts. A client who signs a trust next week should preferably have that trust be under these new rules and not under the old rules. The other thing that was really, really nice, it's a little bit confusing, but it's very nice, is if I leave a trust for my spouse and children, and she has what's called a power of appointment, where she has the right to direct where those trust assets go, then she can really direct those assets to people who I would consider to be a beneficiary. And in the old regulations, you had to consider all the people that that power of appointment was exercisable in favor of as beneficiaries. But how does that work now, Brandon?
Yeah, so they really favorable rules here in the fact that if you exercise the power, so if the spouse exercises the power by September 30th, that determination date, then it's the people that it was exercised in favor of are the beneficiaries. If the spouse restricts the power of appointment, so you say you can only appoint people that are less than 10 years younger than me, so only eligible designated beneficiaries, in other words, then only those people that it's restricted to are taken into account. And then the really favorable rule is if the spouse doesn't exercise the power, it's just like the power doesn't exist, and you look at who would inherit if the power wasn't exercised. So if it's, as Alan gave the example, my spouse is the beneficiary with the power of appointment. If the power of appointment isn't exercised, then it goes to my children. Then for purposes of these rules, the spouse and the children are the beneficiaries. So that power could be exercisable in favor of creditors, in favor of charities, non-individuals. It doesn't matter as long as it's not exercised in favor of those individuals. Those permissible appointees are just disregarded under these new rules.
Right. So those of you on this webinar who are estate planners, your lawyers, your CPAs, your financial advisors, you to start thinking about these IRAs, these large pension accounts, going to trusts that have properly designed powers of appointment and properly designed trust protector provisions. And I would like to get this into place sooner rather than later, because when the Treasury Department issues regulations that are taxpayer favorable, those parts that are taxpayer favorable really only get better. The only thing that changes usually is when the taxpayers show up at the hearings and say, please also give us that, please don't do that to us. So I think the time is now to take all of this in and decide how to best handle it. Now, I want to mention the Teapot system here, and there is a video on our YouTube channel if you search Grandpa Has a Teapot. As opposed to leaving an IRA, you know, 1/3 to the trust for the neurosurgeon child, 1/3 to the trust for the school teacher child, and 1/3 to the trust for the child who's retired. You could leave the IRA into one big trust and let the trustee spray that income among those 3 children over that 10-year period, and at the same time leave an equivalent amount of non-IRA money in another trust like that. So when the trustee gives the IRA money to the school teacher and the retired child, the trustee can give non-taxable money to the neurosurgeon. So that is the Teapot Trust system, and we've written articles on it. It's featured in our books and things like that, and I think they're going to be more popular as people realize that you could put trust protectors in the Teapot Trust and do some very interesting things with them. So pages 12 and following, what we have is a series of charts. This should be very valuable to the practitioner and I know I'm already using them, showing, what was the 2019 law and what happened after 2019, beginning January 1st, 2020. And if I said 2021 before, I apologize. So there is a concept called a see-through trust. It has nothing to do with nudity. I'm sorry for your disappointment over that. But a see-through trust is a trust that can be formed on death or funded on death. It can be funded under a will, which is called a testamentary trust, or it can be funded under a revocable trust. And if you don't satisfy the see-through trust requirements, an IRA payable to the see-through trust has to come out within 5 years, by December 31st of the 5th calendar year following the year of the participant's death. But if you qualify for the see-through trust treatment, then you get to look to the beneficiaries within the trust and use the rules as if those beneficiaries were the beneficiaries. So A, it must be irrevocable. B, by that September 30th designation date, you have to know who the beneficiaries are. They need to be a limited group that you can identify. C, you have to provide information to the plan administrator by October 31st of the calendar year following the participant's year end. And D, none of the trust assets can pay creditors after that September 30, unless the creditors get paid after the death of a tier 2 beneficiary. Now there's two types of see-through trusts. One is the conduit trust. The conduit trust is easier to draft, and it simply says, if and when there is any distribution from the IRA or plan, give it to the beneficiary who is named, which is typically the spouse or a child. And as long as every dollar that comes out of the plan, whether it's a minimum distribution or more, goes to that person, then you only count that person as being a beneficiary of the trust. So that's fairly easy, but that's disadvantageous, because at the end of year 10, when I have to pull it all out, I have to give it to this person, and they may blow it or lose it. So we prefer the accumulation trust. That's the second kind of see-through trust. And with an accumulation trust, whatever comes out of the plan goes into the trust, and then it's up to the trustee to keep it or to pay it out. And typically, if it's paid out, it carries the income out to whoever receives it. So that tells you the definition of a see-through trust and a conduit trust and an accumulation trust. And then Brandon went through the list of eligible designated beneficiaries. So if I leave a trust just for my spouse and for her and for my siblings who were no less younger than me than 10 years, then they are both eligible designated beneficiaries, and the money can come out over the life expectancy of my spouse. The other people that you can do the life expectancy payout include a minor child of the deceased participant. It can't be a nephew or a niece. It has to be the participant's child. And the definition of a child is somebody under age 21. It was going to be different, but the IRS says under age 21 in the proposed regulations. And then when that minor reaches age 21, it can still come out as a life expectancy payment until age 31. So at least we know that now. And then we have disabled and chronically ill individuals. So if you think about it, you have a client with 3 million of assets and $1 million in the IRA and a chronically ill or disabled child. You could leave that IRA to a separate trust for the chronically ill or disabled child, or for the chronically ill and disabled child and the spouse, not benefiting anyone else, to get a lifetime payout, a much slower payout for that chronically ill or disabled individual. And we know from the proposed regulations that the person has to be disabled or chronically ill on the day of death. It can't arise a week after the day of death. It has to arise on the day of death. And then number 5 is that sibling exception. So, while we always think share everything equally among all these beneficiaries, well, first of all, if charity is going to be a beneficiary, let that IRA go directly to charity. Let them not pay income tax on it. But secondly, you can pick and choose between your beneficiaries who will receive the IRA in order to avoid taking the distributions out of the IRA as best you can. Brandon, anything to add to this?
Yeah, no, I think that's a good summary. Those 5 beneficiaries are the ones that get anything longer than a 10-year rule. So just remember those 5, and if you have anyone else, it has to come out within 10 years.
Right. So Brandon, do you want to go ahead and let's cover it one more time, because I know it's hard to get used to this. What has happened with the least is rapidly rule, and what the new and what we call unimproved 10-year rule is?
Yeah, so I'll start with this at least as rapidly rule, and really this applies when you have a beneficiary that's older than the IRA plan owner, because you always have the option of using this at least as rapidly rule if someone has died after their required beginning date. You can elect to just simply use the life expectancy of the deceased plan owner. So historically, that's always been, okay, well, the deceased plan owner has a 20-year life expectancy remaining. I'll distribute it out over 20 years. These proposed regs kind of throw a little loophole in that, and they say that, yes, you can use the deceased plan owner's life expectancy to determine the payouts, but whenever the beneficiary's life expectancy is, maybe that's 15 years instead of 20, everything has to come out by that 15th year. So there's really 2 life expectancies that you have to worry about and consider. We'll see if that makes it through to final regs, because it's very confusing and is one of the first times that that's been introduced and not ever been explained in prior regulations, and nothing has changed with this at least as rapidly rule. So I'm not sure why they decided to add that into the proposed regs. So we'll wait and see what happens there. The most important thing, I think, is the 10-year rule, and this impacts a lot of people that have inherited IRAs. We all thought, based upon the Secure Act, that everything would not have to come out until that 10th year. So, IRA owner dies, you get 10 years of deferral, and then everything can come out. Now, you could take it quicker than that if you needed it, but, income tax planning wise, it's best to defer it as long as possible. The proposed regs say, nope, that is not the case. We have to continue taking IRA distributions over the life expectancy of the designated beneficiary in years 1 through 9, and then everything comes out in the 10th year. So what's the issue there is that someone died in 2020 subject to the Secure Act. All the advisors told someone, you don't need to take required minimum distributions until 2030. Now, technically, you missed 2 required minimum distributions. 2020 was waived because of the coronavirus, so you don't have to worry about that. But your 2021 distribution you didn't take, and there's a 50% penalty on not taking a required minimum distribution. Now, presumably, there'll be waivers for good cause, for relying on the advice of advisors that had looked at these rules, and I don't think anyone's going to be penalized there. But I'm just saying that potentially there is an issue here. Hopefully this won't make it to final regs, but we do have to be concerned about taking RMDs now that these proposed regs are out for years 1 through 9 of this 10-year rule. So be prepared to take RMDs, work that into your financial analysis for this year, and try to make up those previous years as well, so we don't get hit with penalties if this is going to continue on into the final regulations.
And by RMDs, you mean required minimum distributions?
Yes, correct.
Super. Okay, so do you want to cover designated and disregarded beneficiaries one more time?
Yep. So I'll go through the first, I think, are fairly simple here. These on slide 19, there's circumstances where you can just pay someone out prior to September 30th, that determination date. So if your trust maybe provides that I want to leave $100,000 to the Red Cross, and then the remainder goes to my spouse. Well, if you pay out that $100,000 to the Red Cross prior to September 30th, then they're not even considered to be a beneficiary of the trust for purposes of the required minimum distribution rules. So your spouse is the sole eligible designated beneficiary. Life expectancy rule applies. If you have someone that's passed away prior to September 30th, they're disregarded as a beneficiary. And then this nice favorable rule where you have only people that are that a power appointment is exercised in favorable of, all those permissible appointees under the power of appointment are disregarded. So you can appoint to a charity, a creditor, whoever you want to under that power of appointment. You don't have to be concerned with that any longer. The other two interesting rules, as Alan said, you have these concept of tiered beneficiaries. A tier 1 beneficiary, someone who can receive immediate benefit from the IRA, a tier 2 beneficiary, the next in line, and then any beneficiary under that tier 2, so tier 3 and on, is disregarded for purposes of the required minimum distribution rules. And then finally, another new favorable rule that really can disregard a tier 2 beneficiary if that tier 2 beneficiary can only benefit after a minor has passed away. So you get this rule where if you have, say, a minor as a beneficiary of the trust, everything comes out to that minor by the minor's 31st birthday, which is an important distinction. If someone inherits after that minor, then you don't have to consider them as a beneficiary of the trust. Now, if you said that everything comes out right to the minor or that whoever that person is at age 35, so you don't meet that distribution by the 31st birthday, then those remainder beneficiaries are considered as beneficiaries for purposes of applying these rules, and you have to take them into account. So an important drafting distinction there, that age of 31 might be important to look at in your trust as well. And then finally, remainder beneficiaries of conduit trust, you don't have to consider them as beneficiaries. They can just be disregarded. It's only that first in line, whoever's getting the benefit of the conduit trust.
Okay, so what you've seen here, these slides are almost all from our recent article that we published last night for Lineburg Information Services. You have our email addresses at the bottom left-hand side. So if you send us an email and you would like a copy of that Lineburg article, you could just put LISI in the RE line. That stands for Lineburg Information Services. Thursday, if you join us at the Not So Free webinar, we'll be going through these pyramids and explaining what the different options are and different planning strategies that we haven't mentioned. One of which is to leave the IRA to a charitable remainder trust, and then you can get a lot more deferral. Or another of which is to simply leave it to the spouse outright and have the spouse consider signing a binding agreement as to what they'll do with the IRA. I'm not sure that that works theoretically, but we have found that it can work in practice. So that concludes our 30 minutes. Let me mention, we have a book on Amazon called Planning for Ownership and Inheritance of Pension and IRA Accounts. It is updated for the Secure Act, but not for the proposed regulations. We're in the process of updating it for the proposed regulations. But if you would like a PDF copy of this book and you have attended this live webinar, just give us an email that says in the RE line, book, and we'll be glad to send you a copy of it free of charge. So let me go ahead now, and Brandon, do you want to answer some of these questions?
Yeah, I see here one about Roth IRAs and whether the 10-year rule also applies to Roth, and it does. You do have to take RMDs out over the years 1 through 9 of the Roth IRA, so a lot of that deferral mechanism we thought we would have with Roths maybe is not so great anymore. We'll see what the final regs come out with respect to that. Let's see if I have any others. A lot of these are long.
Yeah, children with ADHD and autism could be considered to be disabled. You'll be able to treat them as a minor until they're 21, but then the question is, were they disabled? Was the ADHD or autism significant enough on the person's date of death? And that'll be a rough call for a lot of people, because you have a small child, you don't really know how disabled they're going to be. Yet you're supposed to know as of the date of death. So that brings up a very good point, and I may send a comment in on that one. Does the requirement to take annual did the IRS release the form necessary to include the 1/3 second year of IRA distributions that occurred in 2020? Charles, I don't know the answer to that.
Yeah. Here's another one about a child inherited pre-Secure Act and is taking distributions over their lifetime. Upon that child's death, what applies? And the proposed regs did address that specifically. 10 years after that beneficiary's death, everything would have to be distributed from the IRA, regardless of what's remaining on the inherited IRA's beneficiary's life expectancy.
And then Richard asked a good question. What if the tier 1 beneficiary predeceases the IRA owner, so there's only a tier 2 beneficiary? Well, if that's the case, then really the tier 2 beneficiary is a tier 1 beneficiary. They do have to survive the owner in order to be counted as a tier 1, and then later as a tier 2. Then Mike said, are tier 3 beneficiaries disregarded for see-through determination? Yes, by definition, they are. Lauret says, when do you think the regulations will be finalized? I'm guessing December, January, February, if not earlier, because I think they're well written. They're missing a few things. There's things in the preamble that aren't in the regs, and there's examples that don't quite match. But I wouldn't be surprised if we get this done before the end of the year. And Elise wants the book. So very good. I think that answers all the questions, or do you want to cover one of the longer ones?
Yeah, I think the longer ones, if you just want to email me those to you, I'll handle those with email would be easier for me rather than read them here.
Okay. So those of you in the audience who are still awake and listening, thank you very much for the opportunity to present this. A lot of you attend a lot of our presentations, and we learn more from presenting than we do from any other activity, and we enjoy it. So please do send us your questions, comments, and suggestions. Share us with others, whether you like those other people or not, and have a fantastic rest of Tuesday. Thank you.